Hi, bankruptcy attorney Brian Barboza. Today I'm going to discuss if you file bankruptcy, will you have to go to court? Before we get started, if bankruptcy is something you want to talk more about or you want to explore your options, please feel free to give me a call or go to my website, barbozalaw.com, book an appointment to speak with me for free directly through the website. Okay, so if you were to file bankruptcy, will you have to go to court? And this video really is geared towards individuals and married couples. So if you were to file bankruptcy, the answer is yes, you would have to attend a hearing. So everyone who files a bankruptcy has to attend a hearing. Now this hearing is sometimes called a Section 341 hearing. It's also called a meeting of creditors. Now this hearing is not in a courtroom. It's not with a judge. It's actually with what's called the trustee of your bankruptcy. Okay, there's a trustee that's assigned to your bankruptcy case. The trustee is kind of like an administrator over your case. They're not the judge. They don't make any judicial findings or final orders or anything like that. But they are there to gather information, make sure the information you put in all of your bankruptcy forms is true, accurate, and correct. Figure out what assets make up your estate, make sure you've listed all of your creditors, all of your property, and ask you some other questions that have some legal significance. So these trustees are assigned to your case and they're going to conduct a 341 hearing, also called a meeting of creditors. And it's not in a courtroom. And actually since COVID, all of these hearings have been either telephonic over the phone or been by video like Zoom hearings. And so actually it used to be before COVID, we'd all have to pile into this room and it was really uncomfortable because there was about 5 of these hearings every half hour, so everyone's in there, everyone's nervous, and it just wasn't that pleasant of an experience. Since COVID, now that it's on the telephone and or Zoom, at least you can do it from the comfort of your own home or perhaps in your attorney's office with them, but either way you will have to attend this hearing remotely. And the hearing is somewhat formulaic. They usually kind of repeat the same script over and over again. You will have to take an oath to tell the truth, the whole truth, nothing but the truth. So you are under oath, which means that anything you say is number 1, evidence. Number 2, you can be convicted of perjury if you intentionally lie. And then once they start asking some very straightforward questions, then they get into a little bit more details about the specific facts of your case. But again, it's not the judge, it's just the trustee of the case. Now, that's the one hearing that everyone who files bankruptcy has to attend. In a Chapter 7 case, if you have to go to additional hearings with the judge, that usually means that there's a problem. Okay, if you have to actually go to court in front of the bankruptcy judge, that means there's an issue because we have judges to basically determine disputes and or legal issues that are substantive in nature and could have a pretty big effect on your case. So if you in a Chapter 7 have to actually go to a hearing in front of the bankruptcy judge, that means there's probably a problem in your bankruptcy case. In a Chapter 13, it kind of depends on what district you're in, but there are what are called confirmation hearings, and that's to get your Chapter 13 plan confirmed, and that is where the judge will confirm the plan and make it an order of the court. The issue is some districts, like I'm in the Northern District of California, and oftentimes it will be set for hearing, but it actually doesn't go in front of the judge. You don't have to appear so long as there's no issues and no objections. Then the court, upon the recommendation of the trustee, usually confirms the plan. But if there is an objection or some issue that needs to be resolved, then you may end up having to go in front of a judge, bankruptcy judge, to kind of promote your plan and get it confirmed. So that's it. Yes, everyone has to attend a hearing. It's with the trustee, not the judge. And in most cases, Chapter 7 and 13, if you actually have to see the judge, that means there's probably a problem in your case. All right, that's it. I hope that was helpful. If bankruptcy is something you want to talk more about or explore your options, please feel free to give me a call or go to my website, barbozalaw.com, book an appointment to speak with me for free through the website. As always, thanks for watching this video. I hope it was helpful and have a good rest of your day. Take care. Bye.